Hello everyone. Today I'm going to talk about the case C-718-18, which was an infringement action brought by European Commission against the Federal Republic of Germany on November 16, 2018, and the court delivered its final judgment in September 2021. This case was particularly important for us in our course because it showed very concretely how key concepts that we discussed, like unbundling and NRA independence, actually operates in practice. So to give you a big picture within this case, we can have a glance at the general features of this case. So the Commission's core claim was that Germany had failed to correctly transpose and implement EU rules governing the internal markets for electricity and natural gas into its national law, particularly through the ENWG. Now, the case revolved around four key complaints. First, the incorrect transposition of the concept of a vertically integrated undertaking, the VIU. Second, the incorrect application of transitional or cooling off periods for staff within WIU. The third one was the failure to properly apply rules concerning financial interest, especially shareholdings in the VIU again. And the fourth one, which is very important for us, the infringement of the exclusive powers and independence of the National Regulatory Authority, the NRA. What were the invoked legal provisions? Well, the Commission argued that Germany had failed to correctly transpose these following provisions. Article 2, paragraph 21 of the Directive 2009-72 EC, the third electricity directive, which defined the concept of a vertically integrated undertaking in the electricity sector, and also Article 2, paragraph 20 of the gas directive in the third energy package, which provided the equivalent definition in the natural gas sector. And then Article 19, paragraph 3 and paragraph 8, both directives actually, which dealt with transitional periods, basically cooling off rules, which designed to ensure the independence of transmission system operators from the broader vertically integrated undertakings. So, what we are going to do next is to go through the first and only the last complaints, the fourth one, because technically the two other complaints, the second and the third one, are not strictly within the scope of our course. And for each of these two, we were going to look at what exactly the Commission claimed, how each party argued, and how finally the court reasoned and decided in its judgment in September 2021. All right, let's walk through this first complaint very carefully and step by step, just like we would in a lecture. Now, remember where we are conceptually. We are inside the unbundling architecture of the third energy package. And especially, we are dealing with the definition of a vertically integrated undertaking, or the VIU, which is absolutely central because the whole logic of unbundling depends on identifying who is vertically integrated in the first place. So let's break it down. First of all, what exactly was the Commission complaining about? The Commission's complaint was actually quite precise. It was actually about the Energy Industry Act, or ENWG, a part of EU, Germany's national law, of July 7, 2005, as amended by paragraph 2(6) of the law of 20 July 2017, and how it defined vertically integrated undertakings. So, recalling what we discussed in our lectures, According to Article 2, paragraph 20 of the third gas directive, uh, vertically integrated undertaking means a natural gas undertaking or a group of natural gas undertakings where the same person or the same persons are entitled, directly or indirectly, to exercise control, and where the undertaking or group of undertakings perform at least one of the functions of transmission, distribution, LNG, or storage, and at least one of the functions of production or supply of natural gas. So Germany was supposed to transpose this article into its national law, right? Because it was a directive. But the commission said, okay, look, German national law here, I mean, this ENWG, it defines the concept of a vertically integrated undertaking too narrowly. Somehow that it had limited the definition only to undertakings operating within the European Union. So, more precisely, according to Germany's definition, if an energy company had activities outside the EU, let's say production in a third country, those activities were simply ignored for the purpose of deciding whether the company is vertically integrated. And the Commission's problem with that was very straightforward. It said by introducing this territorial limitation, Germany is not faithfully transposing Article 2, paragraph 21 of the Electricity Directive and Article 2, paragraph 20 of Directive 2009/73, the Gas Directive, in the third energy package, because you know that this VIU has the definition in both directives. So, in other words, one can say that Germany is cutting down the scope of the EU concept. Now, what was the Commission's legal interpretation? Well, here the Commission was doing a classic EU law move, invoking the legal provisions, first text, second its purpose, and thirdly the system. So let's go one by one. On the wording on the text, the Commission said, okay, look, the directives define a VIU without any reference to geography, because there is no clause limiting the VIU concept and its activities within the EU. And when EU legislators do want to limit something territorially, they say so very explicitly elsewhere in the directives. So silence here is meaningful. Then, on purpose, the Commission ties everything back to effective unbundling. The whole goal of the directives is to eliminate conflicts of interest between transmission operators and producer or suppliers, right? That was the logic of unbundling. And here's the key insight, because those conflicts don't disappear just because part of the company operates outside the EU. Why? Because technically, if the same corporate group produces energy abroad and owns transmission infrastructure inside the EU, the incentive to discriminate is still there, right? So the Commission's reading was like this: the concept of vertically integrated undertaking must be broad enough to capture all relevant economic links, regardless of where the activities physically take place. Because what matters is the risk of conflict of interest that is affecting the EU market. And they reinforce this perception with another kind of counter argument. What does it mean? Well, the Commission argued that including non EU activities doesn't mean the EU is regulating third country companies directly, but it just means that when we assess a transmission operator inside the EU, we take into account the full structure of the group that it belongs to. That's all. Now, we learned about the Commission's argument, but the question is now how Germany responded. Well, Germany built a multi-layered defense. First of all, it said, okay, look, member states don't have to transpose directives literally. As long as the substance is preserved, some clarification is allowed. And since the directives don't specify territorial scope, Germany claimed that it is simply just filling a gap. Second, Germany challenged the purpose argument. It said conflicts of interest only matter if the relevant activities actually affect the EU transmission system. But if production happens outside the EU and doesn't materially impact the EU network, then there is no real risk. They even invoked the qualified effects doctrine from competition law and try to link it to this EU energy law. And this is suggesting only conduct with substantial effects in the EU should matter. So here I need to go a bit further in details to make sure that we are on the same page to understand Germany's argument, especially because this is where Germany bring in a very interesting move by borrowing this concept from the EU competition law, which was the qualified effects doctrine. What does that doctrine say? In a simple way, in competition law, the EU can apply its rules to conduct that take place outside its territory only if that conduct produces immediate, substantial, and foreseeable effects inside the EU. So you see the point? The trigger is not where the conduct happens, but whether it has a real economic impact on the internal market. Germany used this as a filter. It argued like not every activity outside the EU should be relevant for defining a vertically integrated undertaking, but only those external activities that actually produce qualified effects on EU transmission system should matter. So in other words, they tried to shift the analysis from a structural test, I mean, how the undertaking is organized, to an effects-based test, or what impact is actually has. But here's the key tension, and this is what made Germany's argument ultimately unsuccessful. The qualified effects doctrine in competition law is about jurisdiction after the fact. I mean, it determines when the EU can step in to regulate specific conduct. But by contrast, the concept of a VIU in the energy directives is part of a preventive regulatory framework. It is designed to identify situations where conflicts of interest could arise even before any concrete effect materializes. So, by invoking the qualified effects doctrine, Germany is essentially saying, like, only actual reasonable impact should count. Whereas the logic of unbundling is like, we regulate the structure precisely to prevent those impacts from ever occurring. So you see the point, the two ways and perceptions contradict somehow each other and are not compatible. Thirdly, Germany raises a sovereignty concern, which could make sense easily because it actually kind of warned that expanding the definition to include non-EU activities would effectively extend EU regulatory power beyond its territory, which could conflict with international law. And fourth, they bring in primary law by arguing that the legal basis of the directives, let's say internal market provisions here, do not justify regulating activities of companies operating entirely outside the Union. At the same time, Germany even linked this to fundamental rights like freedom to conduct a business and free movement of capital. So Germany's position, in essence, was like this: or narrower definition is reasonable, is legally permissible, and it avoids overreach. Now, in the final step, what does the court do with all of this? This is where the judgment becomes really interesting. The court started with the methodology part. It said we must interpret the concept of VIU by looking at the wording, context, and objectives. And then it made a crucial move by classifying VIU as an autonomous concept of the EU law. So it means that member states cannot redefine this concept based on national preferences. And then on the wording, the court was very clear. It said the directives contain no territorial limitation. So reading one into the definition is already suspicious. Then on context, the court situated VIU within the broader framework of unbundling rules, and here especially Article 9. This reminds us that the definition is not neutral because it serves a regulatory function, right? And then when it comes to the decisive part, I mean the objective, the court emphasized that the entire system is about eliminating conflicts of interest and ensuring non-discriminatory access to networks. And importantly, it explicitly said that such conflicts can arise even when production or supply happens outside the EU. Okay, now think about the example the court implicitly had in mind, right? For example, a company produces gas outside the EU and it transports it through its own EU transmission network and might favor its own gas over competitors, right? So you see the point? The logic is very clear here because there is the risk that regardless of where the gas was produced, right? There is no motivation probably for this company to give access on this transmission to anyone else because its own gas is coming even from outside the European Union. And from that, the court drew a strong conclusion. If you exclude non-EU activities from the definition of a VIU, you create a loophole. Companies could structure themselves somehow that production is formally outside the EU, and this way they circumvent unbundling rules. And then the court said this would undermine the effectiveness of the directives, right? So the court adopts a broad interpretation of vertically integrated undertaking, explicitly including activities outside the EU when relevant. And finally, the court dismissed Germany's sovereignty and international law argument. Why? Because it said, okay, look, we are not regulating foreign markets. We are simply defining a concept which is necessary to make EU internal market rule effective. And EU law can take into account external conduct when it has effects inside the EU. And this is perfectly consistent with established case law. So the bottom line, the court sides entirely with the Commission and found that Germany failed to correctly transpose the directives. All right, let's now turn to the fourth complaint because, as I said, the first and fourth ones are within our course scope. This is a really important one because it goes directly to the core of NRA independence, not just in theory but in practice. Now, think back to what we discussed earlier in the course. The whole evolution from the first to the third energy package was about strengthening NRAs so that they are not merely formally independent, but actually capable of regulating the market without interference, right? So interference means here both from the industry, if it comes, or if it comes from the government. And this is exactly where this complaint sits. So let's break it down. First of all, what exactly was the Commission complaining about? The Commission argued that Germany had incorrectly transposed the directives by giving the federal government powers that, under EU law, belong exclusively to the NRA. If I want to be more specific, I would say under paragraph 24 of the ENWG, you remember this German Industry Act, a part of their national law, German government was able to, first of all, set transmission and distribution tariffs. Secondly, determine methodologies for calculating those tariffs. And thirdly, define conditions for network access and balancing services. And the key issue was not just that the government was involved, but that it was issuing very detailed regulations. So it could effectively tell the NRA how to exercise its regulatory powers. So from the Commission's perspective, this was not just a technical issue of competence, it was structural interference with the NRA's decision making autonomy. Then, what was the Commission's legal interpretation? The Commission's interpretation was very clear and very strict here. He said, look, uh, under Article 37 of the Electricity Directive and Article 41 of the Gas Directive, certain powers, especially those related to tariff and access conditions, are assigned exclusively to NRAs. And exclusive here really mean exclusive, right? So even if member states can define the framework in general terms, they cannot first take over those powers themselves, or secondly, predetermine the outcome by imposing detailed rules that leave no real discretion to the NRA. And this is where the core point comes in, because independence is not just about not receiving instructions. It is about having real room to exercise judgment, right? If the government fixes all the key parameters in advance, then the NRA becomes just an implementing body, kind of executive body, not a regulatory body. So the Commission's reading was like this: Germany's system deprived the NRA of its effective regulatory autonomy, which EU law is designed to guarantee. And for that reason, the Commission said, you can't do that. This is intervention, and you are breaching the NRA's independence. And then the third issue was to know Germany's response. because Germany again built also a layered argument against the Commission complaint. So it said, first of all, let's think about member states' autonomy, right? Because especially under Article 194, paragraph 2 of the TFEU, which actually I mentioned in the lectures that this is the only independent article addressing the energy within the TFEU, the rights of member states have been specified. So Germany argued that this article is crystal clear, explaining how the energy policy remains largely within national competences. You remember this paragraph 2 of Article 194, right? It said that those measure, I mean, any measure that the EU bodies adopt, they shall not affect a member state's rights in its main energy policy functions, and even it names some of these functions, right? So as a result, the government uh, and its authority and its involvement is actually necessary to manage major policy choices, as Germany argued. For example, about the infrastructure expansion, about the cost control, about these sort of even very detailed management of the energy system. And Germany said our intervention was necessary for those means. Secondly, Germany invoked the principle of legality and democratic legitimacy. It argued that regulatory powers must be framed by legislation to ensure democratic accountability, and that the government, when adopting these rules, was actually acting in a legislative capacity, not giving instructions to the NRA. Thirdly, Germany argued that the directives do not explicitly require NRAs to set tariffs on themselves. As a result, it was acceptable to have these methodologies defined by the legislature, while the NRA applies them in individual cases. And finally, Germany suggested that EU law does not provide sufficiently detailed criteria. So member states must step in to structure the regulatory framework. So overall, Germany's position was like this. What we did was not interference. It was legitimate structuring of regulatory powers within a democratic system. So now, what did the court do? This is where things actually become really important for understanding NRA independence in practice, because the court started again from the wording of the directives. It emphasized that, look, the NRAs have the power to fix or approve tariffs and methodologies. This is something that we discussed when we were talking about the NRA independence and how it evolved during the third energy package, right? And that also was accompanied by another argument that these authorities are not optional, they are not shared powers. So, in a way that the government of Germany could also practice them. So, according to the court, these are the core regulatory functions which are reserved only and exclusively to the NRA. Then the court focused on the term at least in the directives. It said this indicates that these powers are part of a minimum core competence that must remain with the NRA. So already the court was drawing a line. These are not powers that member states can reallocate. Then comes the key step here, which is the independence, right? And here was the place that the court gave a very strong definition. It said, look, independence means that the NRA must be able to act freely without instruction or external influence, whether from public authorities or from private actors. And crucially, this applies not only to the executive, but also to legislature. So even if the German government was acting through regulations with parliamentary involvement, that did not change the outcome. Why? Because if those rules predetermine in detail how the NRA must act, they still undermine its dependence. This is this is the point, right? And this is the key insight. Because independence is not just about who gives instruction. It is about whether the NRA remains real decision-making discretion. So on such a base, the court then made it very explicit by arguing that granting another body the authority to determine key elements of tariffs or methodologies, it reduces the NRA's power and it is therefore incompatible with the directives. And at the end of the day, it also rejected Germany's argument one by one. Firstly, it said, look, member states' autonomy exists, but it must be exercised in line with EU objectives, not beyond that. Secondly, democratic legitimacy. Well, is it is already ensured at EU level through the legislative process. And thirdly, which is very important here, it's that the directives already provide a detailed EU framework, including regulations and network codes. So there is no gap that justifies national intervention. And finally, the court clarified something very important for our course. That is, NRAs are meant to exercise technical, expert-based, non-political decisions, but within the structured EU framework, not to make political choices, but also not to be controlled politically. And that's the meaning of full independence, because they are the regulator. So the conclusion was clear. By allowing the government to define tariffs and methodologies in detail, Germany had encroached on the exclusive powers of the NRA and undermined, as a result, the independence of the NRA. And once again, the court upheld the Commission's complaint on this case as well. So, as a conclusion, if you take one key takeaway from this part, is this: NRA independence in EU energy law is not just about institutional design. It is about who actually makes the regulatory decision in practice. All right. So if we step back and look at the case as a whole, what we really see is this: the court was consistently trying to protect effectiveness of the internal energy market rules. Whether we were talking about the definition of vertically integrated undertaking, or those two issues of cooling off periods and financial interest that we actually did not discuss, but you can find them there in the court's decision, or the NRA powers. The underlying concern was always the same. I mean, preventing conflicts of interest and avoiding any possibility of circumvention. And in that sense, this case tells us something very important. EU energy law is not satisfied with formal compliance. It requires real and operational effectiveness. So member states cannot just say, like, we have implemented the rules, they have to implement them in a way that actually works in practice. And that's why this judgment is so important for us. It shows how the court, together with the commission, ensures the key principles like unbundling and NRA independence are not just written in the law, but actually enforced in the real functioning of the market. So thank you for your attention. And if questions remained, you are always welcome to communicate with me via my email, or you can find me on the social media always. Have a good time.